This is the American Law Journal.
Is our Supreme Court for sale? Has it lost its ethical direction? That is what a new film is suggesting. Good evening, I'm Christopher Naughton. Tomorrow, a new movie is being released about the Supreme Court. Tonight, you'll get a preview. My four guests weigh in. The Honorable Edward Kahn is with us once again, a former federal judge, the former chief judge of the Eastern District of Pennsylvania. He now arbitrates matters and is an attorney with Blank Rome. Danielle Franco Malone joins us this evening. She is legislative counsel with the Alliance for Justice in Washington, D.C. She's co-writer of the film we're reviewing tonight, A Question of Integrity, Politics, Ethics, and the Supreme Court. Chapin Cimino joins us for the first time this evening. She's an associate professor of law at Drexel Earl Mack School of Law in Philadelphia, and she's with the American Constitution Society, co-founding the Philadelphia chapter in 2003. And the Honorable Gene Cohen joins us once again, a familiar face here, a former Pennsylvania Court of Common Pleas judge, and now with Montgomery McCracken. Let's take a quick excerpt, and we'll look at 3 or 4 of these excerpts tonight from this movie, A Question of Integrity, Politics, Ethics, and the Supreme Court, narrated by actor Edward James Olmos. What happens when a Supreme Court justice shows up at a political strategy retreat? Well, maybe nothing.
In the past few years, Justices Clarence Thomas and Antonin Scalia have attended political strategy sessions aimed at attracting wealthy donors and influencing elections. These meetings were organized by billionaire conservative activists Charles and David Koch. The Koch brothers have a huge industrial empire, and their fortunes can be directly affected by Supreme Court decisions on many issues.
When the billionaire Koch brothers, Charles Koch and David Koch, sent out invitations last fall for a political retreat in Palm Springs, Charles Koch made note in that letter of the past appearances at that retreat by Supreme Court Justices Clarence Thomas and Antonin Scalia.
Neither Thomas nor Scalia disclosed on their federal disclosure forms that they took a trip that was paid for or that was coincided with a Koch brothers meeting. We found out about it because the Koch brothers, when they were encouraging attendance at this year's meeting of conservative activists, said, in the past, our meetings have been attended by Justice Scalia and Justice Thomas.
This is politics. Bare-knuckled, big money, Republican-Democrat politics. It would be wrong for a justice or a judge to go to one of these events.
This is dubious conduct in private spaces, and both of those things are in doubt to me in terms of judicial conduct, but both of them together is particularly toxic.
Attending this sort of overtly political event would be a violation of the code for any other federal judge.
When we get into a realm where justices attend events or demonstrate support for organizations whose bent is clearly, political in ways that are identifiable, they begin to suggest to the public that maybe you don't have a shot to convince me.
Danielle, let me go ahead and pose the first question to you. You're a co-writer in the film. As I looked at the entirety of the film, I noticed curiously that it appears not to focus on any of the so-called liberal members of the Supreme Court. Was this an editorial decision, or did you simply not find anything?
Well, to be honest, Chris, the reforms that we are advocating would apply to all members of the court on both sides of the ideological spectrum. This issue did come to our attention after a handful of justices were discovered to have been engaging in the sorts of behavior that would violate the ethical rules if it applied to the Supreme Court. And so that is how it came to our attention. And there does seem to be a handful of justices that are engaging in this sorts of behavior and showing a seeming kind of disregard for public confidence in the judiciary. But the reforms that we're advocating are nonpartisan, non-ideological. We just think that Supreme Court justices should follow the same ethical rules that all other federal courts or federal judges already follow, and we think that that's something that's good for the administration of justice, period.
Well, Danielle, let's go back about 7 years ago. I think Ruth Bader Ginsburg appeared before the National Organization for Women. There's money there. There's certainly politicization of issues there. Might it not have helped the film if you had included something along those lines, even if you didn't feel it measured up to Scalia and Thomas meeting at a Koch convention out in the desert?
Well, you know, one distinction that we think it's really important to make is that the code doesn't require that judges isolate themselves from society. In fact, the code encourages judges to go out and speak to organizations. The line drawing is really when it comes to engaging in political activity and speaking at fundraisers. And so when, you know, justices go out and speak to ideological organizations, that's not something that we take issue with. It's really the specific behavior that we point out in the film of fundraising and politicking. And even attending fundraisers is not off limits, so long as it's not a political event and the judge does not speak or allow their name to be used to draw people to the event.
You would have been just as assiduous if, let's say, a Breyer had showed up at a Hollywood fundraiser or a political fundraiser with George Soros.
Certainly, that would be equally concerning to us. It so happens that it seems that there are a few justices that are the ones that tend to be engaging in this sort of behavior, but we would be equally concerned about some of the more progressive justices engaging in this sort of behavior as well.
Okay, that clip, Judge, what if anything disturbs you about what we just saw a few moments ago? And I know you know some of these people personally as well.
Yes, I do. I do know Justice Scalia personally, and I have a very high regard for him on an integrity basis and on an intellectual basis. I think it's a decent argument that is made in the film that the Supreme Court justices should abide by the same rules that the circuit judges and the district judges must follow. And I think that that's something that we could talk about. There's something else here, though, that needs to be focused upon, which is the independence of the judiciary is very important. And when other people try to tell the judiciary what to do, it interferes with the checks and balance system of our Constitution.
Chapin, what did you find? Did you find anything disturbing about Scalia and Thomas appearing at the Koch brothers convention, where, again, they raise a lot of money for some very conservative political causes? Or might you just say, hey, look, if they're going to be pals or friends with those kinds of people, does it really matter if they're at that event? Or does impressions really count for something here?
Well, I think you hit it. Which is pals or friends is one thing. And of course, the reality is folks with a lot of power in these sort of small, limited circles are going to move amongst each other and get to know each other. And there's no way that that's not going to happen. And I don't know why anyone would want that to not happen. I think the problem is the appearance where money is changing hands. And my understanding of those Koch brothers meetings out in the desert, as you said, where they were actually litigation planning sessions, and Danielle can correct me if I'm wrong on that, but when you're planning strategic litigation on how to overturn or advance certain ideological goals, that's tough. That's tough to defend that.
Is that what happened there, Danielle?
Well,
do you know if there was litigation strategy going on there?
I think the real problem was there was electioneering activity taking place. The intention of the retreat was to draw wealthy donors and to plot out how elections could be influenced, which is something that would be totally off limits for any lower court judge and really, calls into question the public's confidence in our Supreme Court justices as impartial arbiters of the law.
Well, what I found curious is that this really didn't come out until a year after Scalia and Thomas appeared at this event, because apparently mum was the word, and it showed up in a brochure promoting their following year's event.
Yeah, the event is it's extremely secretive. Those who attend the event are asked to sign a confidentiality agreement agreeing that they won't discuss the event outside. And neither of the justices, as the film pointed out, disclosed that they had attended the event. We only found out about it because one of these secretive invitations to the 2011 event was leaked and made public. And that event had touted the fact that Justices Thomas and Scalia
a brochure was leaked. Certainly that had have been public knowledge, even if it was limited public knowledge.
It was actually quite confidential, and it made quite the story when that program for the 2011 retreat broke. It was big news.
I think there's something unfair, however, when we use the expression where money was changing hands, with the implication that somehow Scalia or Thomas were taking money for something, and that kind of statement gives the impression that the judges were on the take and they were being fixed by these people for money, and I cannot see that having
Do you really
taken place.
do you think anyone here on the panel tonight, judges, has suggested that?
Well, by that statement of money changing hands,
okay,
is always the implication that someone was being fixed. Mm-hmm. Now, the fact of the matter here is, I think that it was probably inappropriate for them to go to something like that because it looks bad, and if it looks bad as far as judges are concerned, that it is bad. However, we have to really understand that the Supreme Court of the United States has two functions, one as a Supreme Court, a judicial court, and the other is really the Supreme Political Court determining constitutional issues. And some countries have two different courts like that, one in France, like the Cour de Cassation and the Conseil d'Etat. One deals with constitutional issues, the other deals with judicial issues. But here we have the one court doing the same, this one thing, and to expect them to be impartial in all matters and judicious in all matters is maybe asking too much for what their function is.
Let's go ahead and take a look at another excerpt from this film, A Question of Integrity, Politics, Ethics, and the Supreme Court. And let's take a look at Clarence Thomas, his wife, and political fundraising.
Supreme Court Justice Clarence Thomas is coming under increased scrutiny after the New York Times revealed new details about his close ties to Dallas real estate magnate Harlan Crow, a prominent Republican millionaire. A company controlled by Crow is bankrolling Thomas's pet project, a nonprofit museum in Thomas's hometown of Pinpoint, Georgia. In addition, Crow provided $500,000 to allow Thomas's wife to start a Tea Party group, and he once gave Thomas a $19,000 Bible that belonged to Frederick Douglass.
Reporters discovered that Mr. Crow has given Clarence Thomas trips on his private jet, a cruise on a luxury yacht, even a $500,000 contribution to the Tea Party organization, Liberty Central, headed by Thomas's wife, Virginia. On his financial disclosure forms, Justice Thomas failed for several years to report his wife's income. Virginia Thomas worked for the Heritage Foundation, which weighs in on many major political issues of the day. But for over a decade on his yearly financial disclosure forms, Justice Thomas checked the box none for spousal income. When the news broke, Justice Thomas quickly corrected the forms, claiming he had misunderstood the reporting requirements.
When the information isn't given and then the response is simply, I forgot to fill out the form for a bunch of years, it made it appear as though it was inconsequential to him.
The Judicial Code also prohibits judges from lending their names and prestige to any fundraising activities. But Justice Samuel Alito has served as a keynote speaker at fundraisers for political causes, like the Conservative Intercollegiate Studies Institute. He's also attended and spoken at fundraisers for the American Spectator magazine. When reporters asked whether attending the American Spectator dinner was appropriate, he said it was not important.
And I think that's intriguing, that the idea that he could be participating in a political activity that's a pretty nakedly political activity, and that people would be interested in that, shocked him.
If I'm a judge and I go to their annual fundraising dinner, it would suggest that, I think to the average person, that I'm supporting that cause. I'm lending my name and presence to that cause. And it seems to me that's something a judge and or justice should stay away from.
Let me, again, if I may, go back to my judges first. These are tough questions, even for the judges. See, we're used to getting tough questions from you, Judge.
Well, I think if I were some sort of ombudsman on this issue, I think it would be a good idea for the Supreme Court to follow the rules that other judges have to follow. As I say, the problem is if Congress tries to enact rules like that, it could be perceived as interfering with the judicial branch of government. Remember, under our Constitution, judges prevent the tyranny of the majority. So judges must be independent, and they should be free to mingle with people. They should have friends who give them gifts. Should it be disclosed? Probably. But I don't think that any of this has changed any of the decisions on the Supreme Court. I can't think that it would have.
Judge Cohen, but what happens, though, when a judge's wife, a spouse, is involved in inherently political activity, that's going to create an inherent problem one way or the other, don't you think?
Well, they may have 60 years ago, but who could control their spouses now?
All right. I didn't mean between spouses per se, but it's going to, and you probably didn't either. You're just going for a good laugh there and you got it. But don't you think that any Supreme Court justice is going to run into a bog if their spouse is involved in what some might call fervent political activity? And I don't care if it's a liberal or a very conservative.
Well, why should Justice Thomas's wife be precluded from political activity?
But
she
here
should not
again,
be.
I think it's the appearance that's really the problem, because I think something that I would agree with Judge Kahn on, and probably even Judge Cohen, is that I don't think any of this activity, even the duck hunting trip, the famous, infamous duck hunting trip, changed any decision in any way. If Justice Scalia happened to be predisposed toward the arguments in Cheney 1 in favor of Cheney, it's not because of the duck hunting trip. You know, it's because he comes to law and he comes to the seat on the bench with a particular way of looking at the world. And the duck hunting trip is really kind of, in my view, a tempest in a teapot. It's the appearance that's the problem.
And Judge, go ahead, Danielle.
If I could just jump in for a moment. It's important to note here also that the codes of conduct place the burden on the judge, not the judge's spouse. The judge's spouse is free to engage in whatever sort of political activity he or she wishes, although the code does say that that may increase the chance that a judge might have to step aside from a case and recuse themselves if there's a conflict of interest. The other important thing here is that Justice Thomas really took it a step further by making a speech in which he said, "I agree with my wife." The code says that judges should distance themselves from their spouse's stated political positions. And of course, the other big problem here is that Justice Thomas failed to disclose for over a decade the outside income that his wife was receiving, which is something that the federal rules already require. Most federal employees are required to disclose this sort of information, and we don't really know why Thomas didn't disclose it, but that's the other big problem here.
Well, maybe it was a mistake, but in either event, if the Heritage Foundation, which I believe is what Mrs. Thomas is handling, were a litigant before the Supreme Court, I think it would be clear that Justice Thomas would have to recuse himself, and I believe that the other members of the court would kind of force the issue because the appearance would be such that the integrity of the court would be questioned. But normally, that these groups, do we know of any case in which the Koch brothers are litigants in matters that are appearing now before the Supreme Court? I think not. They're just people with points of view that are trying to get them across to anybody who will listen.
Yeah, that's an interesting point, Danielle. I think your film said that the Koch brothers have matters which could very well appear before the Supreme Court, although, again, the film wasn't exactly abundantly clear about that.
Yeah, you know, there haven't been any cases involving the Kochs before the court that I know of, although I think the real problem is not that there might be a conflict of interest, but it's the appearance issue again. Judges are asked to refrain from engaging in political activity so that the public has confidence that when they walk into a courtroom, they know that the judge is going to issue a decision that's not going to be influenced by the judge's political preference or outside special interest. And it's a pretty reasonable thing that we ask judges not to engage in political activity when they take the bench. So when we have judges attending these sorts of Koch retreats, it kind of signals to the public that they might have a particular preference one way or another in a way that we don't want judges to signal.
That hasn't been the history in the United States, though. Justice Frankfurter had a reputation of being very close to President Roosevelt, and the two of them would plan litigation and matters that were of the utmost importance to the United States. And I think perhaps the way we look at this is evolving, and it perhaps is going to take some time for the Supreme Court to come around to this thinking. They probably will in the future, but historically, it's been exactly what went on all the time.
Interesting.
Justice Scalia wrote about this in his memorandum opinion where he declined to recuse himself from Cheney 1. Some of these examples throughout history where presidents have had close relationships with Supreme Court justices. And then it does make you wonder, have times changed, or are we just more suspicious now, unjustifiably? You know, I don't know. I don't know answers to those questions. When I hear those stories and I read that in Justice Scalia's memo, I think, okay, but I'm not quite sure what to do with it.
And the question we should ask ourselves at this point, as we queue up the next excerpt, is what would encourage a Supreme Court justice to recuse himself or herself.
But it's not just what justices do off the bench that threatens to undermine public faith in the judiciary. So does failing to step aside from a case when it appears a judge may have a personal or financial stake in the outcome. This fact came into stark relief in a case that thrust Supreme Court ethics into the headlines.
Early on in the Bush administration, Cheney headed what was called sort of an energy policy task force. And the allegation was that he met with a lot of lobbyists for the oil and gas industry to draw up an energy plan.
The Sierra Club wanted to know who were the people who were part of this advisory group. We weren't invited to the meeting, so who was there? And the vice president argued that he did not have to release that information, that it was in fact covered by executive privilege.
The Sierra Club sued, and Vice President Cheney lost in the lower courts. He appealed to the Supreme Court. Just after the court decided to hear the case, LA Times reporter David Savage heard that Vice President Cheney went duck hunting in Louisiana with Justice Scalia.
I sent a note to Justice Scalia and said, "Is this really true?" I said, "You actually went duck hunting with Dick Cheney the week after the Supreme Court agreed to hear this case?" And I said, "Doesn't this raise some sort of, ethical or conflict of interest question?" So he sent me back a sort of a one-page letter, said, "Yes, I went down there. It was a lousy week of duck hunting. But he said, I don't think it violates any code because the code says something like, a judge should not participate in any case where his impartiality might reasonably be questioned." And he said, no one would question my impartiality in this matter.
But did Justice Scalia step aside? No.
Judge, should he have?
I think he probably should have. I think it would have been better for the court as an institution if he had. On the other hand, I don't think it mattered with the decision.
He didn't cast the deciding vote, but it certainly did call into question the court's independence and whether or not he should have been sitting on that case. And it really, I think, brings to the forefront the big problem with the way that recusal is handled at the Supreme Court, which is that each justice gets the final word on whether or not they can participate in the case. Mm-hmm. For lower court judges, if the judge gets it wrong, it can always be appealed to the next level. But at the Supreme Court, that's the end of the road. So we think there needs to be some sort of mechanism for reviewing those decisions to make sure that they get it right.
I think the decisions the Supreme Court justices make are too important for us to somehow attack them because there appears to be some kind of problem. If the decision is going to be tainted by the judge's involvement because of some personal issue, it cannot be a financial issue, that's clear, but if it's some personal issue or a personal preference, I don't believe that we should be attacking the entire decision based upon one of the participants.
Not the decision, Judge, and I think that's what Judge Kahn just made clear. It really didn't change the outcome. But let me ask you a question. If you knew someone was going to be litigating before you in a month or so, would you go out and play golf with them? Would you go out in public place and have lunch with them? I'm guessing no.
I would try not to. There's no, it's clear.
You might bump into someone at the Palm restaurant.
But I was a trial judge where decisions concerning facts and what's true took place. And there, the participation of the trial judges is much clearer as to what kind of decisions are made, because the finding of facts are sometimes subjective. But when we come to a Supreme Court decision where all the facts are set, the law is then presented for a justice to make a decision. These kinds of areas are not all that important. Like I said, the most important thing is that the judge has a financial interest, either he or his spouse or someone close to him, in the outcome of a piece of litigation before the Supreme Court. Then they absolutely must recuse, or there's some possible other involvement that should be investigated.
I would disagree with that a little bit. I think it's precisely because the judiciary is so important and depends entirely on the public having faith that it's an independent and impartial institution that these appearance questions are really so important. It's probably true that Justice Scalia's vote wasn't changed by the outcome of that trip, but it certainly looked bad to the average member of the public. And the recusal law requires a judge to step aside whenever a reasonable person might think that they have a bias in the case.
I mean, what the average person would think, I doubt that that's the standard for recusal.
It's if your impartiality could reasonably be questioned.
That's the answer.
Let's roll in Jon Stewart here, because I think East is East and West is West, and never the twain shall meet. This is also from the movie Question of Integrity. Jon Stewart.
Supreme Court Justice Antonin Scalia found himself in a bit of controversy stemming from a duck hunting trip he went on with Dick Cheney just 3 weeks after the court agreed to hear a case directly involving the vice president. Angrily denying his objectivity is in any way compromised by his friendship with the vice president, Scalia writes, "If it is reasonable to think that a Supreme Court justice can be bought so cheap, the nation is in deeper trouble than I had imagined." In a related story, the nation is in deeper trouble than Antonin Scalia had imagined.
Danielle, you folks raised that in the film. It might simply come down to a difference of opinion. For example, Scalia and Stewart are never going to see eye to eye on that issue.
Well, I think that's precisely the point, that it's not a subjective standard of whether or not the judge is actually biased. It's whether or not their impartiality can reasonably be questioned. And that's why the individual judge is oftentimes the worst person to decide whether or not their impartiality could be questioned or what a reasonable person might think. I also would like to just point out that the reforms that we're calling for, asking for the court to adopt the Code of Conduct and provide some review of recusal decisions, are things that the court could and should do on its own. There have been concerns raised about whether or not this is an area that Congress should get involved in. And I think that we all would agree that the ideal solution would be for the court to agree to adopt these reforms voluntarily, and that's something that we're calling for.
And folks, if you'd like to see the movie in its entirety, you can go to the Alliance for Justice website. Simply type in www.afj.org. A Question of Integrity, Politics, Ethics, and the Supreme Court. I want to thank my guests for joining me tonight. Chapin Cimino, an associate professor of law at Drexel Earl Mack University of Law, and the Honorable Gene Cohen joining us this evening, former Pennsylvania Court of Common Pleas judge, the Honorable Edward Kahn, former federal judge and co-writer of the movie A Question of Integrity, Danielle Franco Malone. So for all of us here at the American Law Journal, until next Monday night, case closed.
This week's American Law Journal has been made possible in part by the Alliance for Justice, fighting for a fair America. Go to afj.org. The American Constitution Society, promoting the fundamental values of the U.S. Constitution at acslaw.org. Scheller PC, a national law firm preserving the constitutional rights of consumers since 1977. Martin Banks, remaining steadfast to its mission to defend and protect injured workers. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.